Hello viewers, in this lecture we will talk about the Specific Relief Act 1963. You might have come across so many laws, say Indian Penal Code, Indian Contract Act, Evidence Act, Civil Procedure Code, Criminal Procedure Code, Specific Relief Act, the Arbitration and Conciliation Act, and so on and so forth. Do you find any difference between these laws? The answer is yes. Look at the provisions of the Penal Code, the Contract Act on one hand. Look at the provisions of Civil Procedure Code, Evidence Act, etc. One set of laws, they create rights or recognize rights or ensure rights. The other set of laws, they make provision for implementation of those rights or making effective those rights conferred by the law. Thus, let us be clear that there are two broad categories of laws. One is substantive laws and two, procedural laws or adjunctive laws. Now, kindly bear in mind that when the word procedural laws are used, please do not misunderstand it as the book of instruction often prescribed for the regular working in the government departments or banks or insurance companies. Such manuals are there even in civil court and criminal court under the caption of civil manual and criminal manual, where the office is run under those instructions. We are not concerned with those books of instructions. These procedural laws in substance are themselves laws. It is only just a category of law that is given the nomenclature of procedural law. And therefore, do not misunderstand the procedural laws with book of instructions. Why I am emphasizing this point? The procedural laws themselves contain principles, and those principles are so complex that it is often difficult to understand and practice easily by most of the people. I would just give you one simple example of the doctrine of res judicata, the principle of civil law. Once there is a binding decision by a competent court between the parties, then that becomes final. No party is permitted to litigate again. Now, is it not a fundamental principle? Would you compare it simply with a book of instruction? The answer is no. You may think that why I am talking so much about procedural law. The answer is, look at the provisions of the Specific Relief Act. What is the nature of the provisions? Does it create or recognize rights like Contract Act or Marriage Act or Succession Act? The answer is no. It essentially concentrates on the reliefs that can be granted in civil litigation. First of all, the simple question is, what is the usual relief granted in civil cases? The obvious answer is compensation. And to what extent? Look at the road accidents. In case of motor vehicle accident, someone has died. Can law put into the deceased body life again? The answer is no. There is no remedy. Can court say that no, we are helpless, we cannot ensure you any remedy? No. Therefore, law has found out a way that yes, even in such cases, there must be some relief, financial help, which would mitigate the harshness of the accident, and therefore monetary compensation, though it is no substitute of the deceased. Similar is the situation when someone sustains fracture or bodily injury. The compensation is in money terms. Therefore, you can as a rule say that the remedy in law, the relief in law is compensation. And even in such extreme cases. But still, the question arises that can there be no other remedies? And we find the answer in the Specific Relief Act. Though the usual remedy in law is compensation, there are circumstances where certain special reliefs are required to be considered and granted. It is obviously on the basis of equity. And friends, mind well, law and equity, two big chapters in the legal system. And equity never ends. As it is said that equity is a law reform. Whatever law comes, new equities may be created which may reform the law, and then that process continues to go. It will never come to an end. But still, the usual common remedies in many of the cases which the legal system found, yes, they are codified, and codified under the name of Specific Relief Act. So various reliefs which were being granted by courts then and most commonly found, yes, are put into this. Therefore, immediately the question that would arise is, can there be only the statutory reliefs which are specified in the Specific Relief Act alone, or there could be many more specific relief? As I have told you earlier, law and equity continue to go hand in hand, so there cannot be list of final specific relief. But the reliefs which are statutorily recognized are found in the Specific Relief Act. I will first talk about the relief provided in Section 6 of the Specific Relief Act. Why I am making reference of Section 6 here? If you go to civil court, often you may come across the talk that Section 6 suit is there. And what is that? It is under this and no other act. And what it is? Recovering possession. What does it say? It is an extraordinary remedy. When someone is forcefully dispossessed without his consent and without following procedure prescribed by law, yes, this Section 6 gives him or anyone claiming under him the right to move the court by way of filing a suit under Section 6 of the Specific Relief Act and get back the possession. But the limitation prescribed is that such suit must be filed within 6 months from the date of dispossession. Obviously, this is an extraordinary relief. The real object of this section is not to protect the person dispossessed, but to tell the person who is dispossessed that you cannot take law in your hands and dispossess anyone in this way. If you want possession from him, initiate legal proceedings and get back the possession. Even if you have a better title and you are entitled to recover the possession, file an appropriate suit for that and take back the possession even after decree is passed in Section 6 to restore the possession. But you cannot take law in your hands. The rule of law must be maintained, and therefore, if you have taken possession in an unauthorized manner, you must first return it, restore it. Obviously, it is presumed that government functions according to rule of law. Often this becomes questionable, but then it is a presumption of law, so we also have to presume. No such suit can be filed against the government. The answer is, as I have told you. Therefore, This being an extraordinary remedy, one more provision is made that no further appeal or review can lie against any decision passed by the court in section 6 suit proceedings. Again, it is logical that this being an extraordinary remedy, the object is to prevent anyone from taking law in his own hands and to protect the person forcefully dispossessed, and therefore it must end somewhere, and therefore no appeal or review against the same. The second such specific relief is about specific performance of contract. Once you know the Indian Contract Act, what is valid contract, the performance is there. Performance is the rule. And mind well, it is not the Indian Contract Act that teaches us that you have to perform what is promised. We have been living in a system where Raghupal Rit Sada Chali Aayi, Prana Jaye Par Vachana Na Jaye. You must perform your promise. And that is what Contract Act says. So the performance is rule. And therefore, if the other party deviates from his obligation, law prescribes the circumstances where there can be specific performance. In other words, perform as promised. Whatever you have said, you must do it. And Specific Relief Act prescribes circumstances under which movable as well as immovable there can be specific performance of it. Third relief is cancellation of document. Parties often agree. It used to be in earlier times when individual shops were doing the business. Even when the property is mortgaged, it would be a contract for sale. If the money is returned, property would be released. If not, there will be agreement, contract for sale. In a given situation, the borrower has returned all money, but the sale executed is not returned. The borrower may file a suit and tell the court that, look here, sir, this agreement was entered into in substance for loan. I have returned it. The document is not being returned or destroyed, and there are all chances that it may be used against me in future. Therefore, having paid the entire loan, kindly cancel the document. Yes, you can file such suit under the Specific Relief Act and get the relief. Next relief is about the rectification of instrument. Say while writing a check, instead of writing 10,000, through oversight, 10 is added. Or when you have not written in words, the holder of the check, the payee of the check, adds that. And you come to know about the alteration. You can move the court and tell that, look here, sir, the transaction was only of 10,000 rupees. It was intended to be for 10,000 rupees. If it is not rectified, presumption under section 118 of the Negotiable Instruments Act is that the check is drawn for 1 lakh of rupees, and therefore I may be called upon to pay 20,000 more. Hence, rectify the instrument. If the court finds substance, yes, court can rectify the instrument. Similarly, one more relief is rescission of contract. You have come across flaws in consent, where the transaction becomes voidable. Having signed the agreement, when the coercion is over, when the undue influence is over, you go to court and tell the court that, look here, sir, the consent is obtained under coercion or undue influence. I withdraw it and rescind the contract. If the court finds the substance, yes, can pass a decree for rescission of contract. The most common relief, most popular relief in civil matters, injunction, which often colloquially we refer as stay, yes, has its roots in specific relief, inequity. So there is a dispute amongst brothers, and one brother is isolated by others, and somehow or other in an ancestral property they manage to keep that brother out of the property. When that ousted brother files a suit claiming his right, obviously, you know, the delay in our courts is proverbial. Per court, 1 decade. Now, in property matters, appeals are common. So it may take 2-3 decades. Would you expect that the ousted brother should remain out of the property for 2-3 decades? And perhaps we don't wish, but when the decree is passed, he may not be there. Can that be the object of law? The answer is no. And therefore, law provides for the relief of injunction and says that during pendency of the litigation, one can be protected by way of injunction. And there could be permanent injunction also after the litigation is over. That can be dealt with separately when we deal with injunctions in general. Last of the specific relief specified in the Act is declaratory decrees. In the previous example itself, the status of the estate brother itself is disputed, contending that no, you are not our brother. If you are not brother, you will not be entitled to share in the ancestral property. So first you will have to establish your status as son of the deceased father. Therefore, establish your case, get the declaration that the one is the son of the deceased and the brother of other defendants, and then claim your right. If your status itself is in dispute, obviously you cannot get any relief. So, these are the different types of specific reliefs which are recognized by law. In a given case, looking to the facts and circumstances, court may grant appropriate relief similar to the one prescribed under the Act or found fit in the facts and circumstances of the case. Ultimate object of law is to give relief to one whose rights are violated or to whom injury, obviously legal, is caused. And therefore, there should be answer in case of all violations of law. Thank you.